Yes, Mr. Green.
My Lord, before the short adjournment, I indicated that there had been 4 previous cases involving applications like this where the Secretary of State had chosen not to intervene, and that includes, of course, Great Yarmouth, where an injunction was in fact granted.
Yes. Ippswich is one, Great Yarmouth is one. What are the other 2?
Ippswich and East Riding of Yorkshire were 2 cases heard at the same time. There was Fenland, and then there was Great Yarmouth.
Right.
And of course, in each of those cases, as I submitted earlier, evidence was put in on behalf of the Home Office by an official. Moving on to what happened in this case, we have the witness evidence from the Home Office, and that appears at tab 7 of the Secretary of State's claim bundle. And I would simply invite the court to go to page 42, paragraph 18, and read it again. I'm aware it's already been looked at once.
I think it's now accepted that there was no application for the hearing to be delayed.
Well, that's right. Paragraph 5 of the judge's oral judgment deals with it, and that's a mistake. It's not quite clear how that arose, but it's a mistake. I'd ask the court to contrast that with the evidence put in on behalf of the hotel owner in the supplementary bundle at SB 1632. Paragraph 8 and over the page, including paragraph 9. And again, simply invite the court to read those 2 paragraphs. It can be seen in paragraph 9 that the maker of the statement says, I've contacted CTM, told them about these legal proceedings since they're not a named party and were not served the court papers. I was told by CTM that the Home Office was not getting involved. There appears at that point to have been a conscious decision not to get involved.
We don't know who spoke to whom, did we?
Well, this is the best evidence, or the only evidence we have of what transpired. All we do know is that nothing was done by the Home Office until the 15th of August in the afternoon, when the hearing was nearing completion.
Yes.
The judge dealt with the circumstances in his short oral judgment. Paragraphs 4 to 7, and it's not suggested he got any of that wrong. So he was confronted with an application, the hearing having already occurred, about to hand down judgment, an application for the Secretary of State to be joined as an intervenor. Application would have to be opened up again.
Yes.
In effect, there'd be a second hearing.
Yes.
And what the judge did was to
An
exercise...
alternative would have been for counsel for the Home Secretary to have waited hand down of the judgment and then made an application to the court for the Secretary of State to be joined as a party and to apply for the injunction to be discharged. Being another way of doing it.
Well,
Anyway,
yes. Anyway,
the judge said no.
the judge said no.
The judge says at paragraph 6, the SSHD accepts that no action was taken to participate in proceedings until the 15th. Not until the 15th. The SSHD appreciated the breadth and nature of issues to be considered. One thing one ought to say for the benefit of non-lawyers involved is that it's convenient shorthand to refer to the Home Office as a whole as the SSHD. It's not suggested that Ms. Cooper herself did or failed to do any of this. So it could be anybody.
Of course.
Yes.
The judge was exercising a case management discretion, a broad one. And in my submission, his decision was well within the bounds of that discretion. I'm going to go through the appeal grounds as raised by my learned friend's skeleton argument, if I may.
Yes.
Relatively quickly, because I do deal with them in the skeleton argument. At page 4 of my skeleton argument, ground 1, the judge misinterpreted the gateway test. This is the point that was canvassed very briefly this morning. Did the judge apply a necessity test as opposed to a desirability test? It's not a point Mr. Brown developed in his submission today to any extent, as far as I could see, and in my submission it involves a simple misreading of the judgment. Ground 2 is an allegation that the judge was in error in saying that both the council and Somani were ad idem as to the public interest issue. And again, in my submission, that's just a straightforward error. He said, yes, they were ad idem as to the relevance, but not the weight. And that's plain from his judgment. Again, that wasn't a point developed by my learned friend today. Ground 3, the judge urged in holding that the direct impact of the injunction on the Secretary of State's statutory obligations was not relevant. The judge held no such thing. If one reads what he said. Again, not a point developed today. And ground 4, the judge urged in setting the gateway test. I've already covered that. The last ground is that the judge erred in the exercise of his discretion. So if, the judge said, if I'm wrong on the gateway point, if they should be admitted, or rather, if the gateway is satisfied, nonetheless I would not join the Secretary of State as an intervenor for the reasons that he gave. And essentially, it's because the Secretary of State came too late to the party. The hearing had already taken place.
Is it relevant that proceedings were issued on the Monday. Secretary of State, the Home Office, were not notified at that stage. Somani notify CTM. CTM in turn notify the Home Office. The full day hearing was obtained on 3 working days' notice. Seems to me as an old hand in having made injunction applications for many years at the bar. Almost miraculous that a full day hearing could be allocated on 3 days' notice at the absolute minimum. And so, although the Home Office only took steps on the Friday, which was, as it happens, the day of the hearing, it was only 3 days after they had become aware of this litigation at all. Is that relevant?
Potentially, my lord, yes, of course. Timing was an issue, and if the Home Office had not been at fault at all, if they'd done all they possibly could to put before the court all that they wanted to, and had just failed because it was impractical, then yes, that would be a relevant consideration. But that wasn't what in fact happened. So I accept in principle, if there's a good explanation for the failure of the Home Office to respond in time, relevant of course, that wasn't the case here.
Is it also relevant that until they decided to move on the 11th of August, Epping had given no indication at all in any pre-action correspondence to Somani or anyone of an intention to take such steps?
I didn't know, not relevant for the purposes of this exercise. If I can take that in stages, it's certainly not suggested, I think, by either defendant that had a pre-claim letter been sent, it would have changed the conduct of the defendant. It's not suggested that the hotel operator would have stopped using the hotel had a pre-claim letter been sent.
No, of course not. But they would have had more time.
They would have had more
to
time. Yes.
Instruct solicitors, ask CTM what to do, maybe ask the Home Office what to do, and so on.
Yes. The application was made in accordance with the rules of court. It's not suggested that there was a breach of the rules in any way by the claimant. CTM was contacted quickly and they responded quickly. We have the email from CTM on the 13th of August.
But that's not, I mean, that reflects well on Somani, not on Epping. Epping gave no one any notice and they had time of what they were intending to do.
Well, that's not contested. That's understood.
There was no communication between Somani and Epping from the 15th of May till the 11th of August, and no letter before action. Why not?
Well, I don't know. I will need to take instructions on
Do you do that, please?
There were, of course, attempts to persuade the Home Office to change tack.
Yes.
And there were...
Well, we've seen, of course,
yes.
the letter sent following the council meeting.
Yes.
But could you take instructions,
yes,
please, on why no letter before action was sent to Somani?
If I may turn my back.
Of course.
understand, no such letter was sent because of the perceived urgency of the matter. The Lordship would have seen in the papers reference to public protests and public disorder, and it was felt that the matter couldn't simply wait for correspondence between the parties to result in some sort of action. It required immediate action, an immediate application to the court.
Sorry, when the bundle shows signs of careful and detailed preparation. I think it's a legitimate question to ask, when did that process begin?
Again, I'll need to take instructions.
Please.
My Lord, I'm told that the decision to proceed with the application was taken on the 5th of August.
But that's over a week before proceedings are issued.
Well, not quite. The Tuesday before the Monday. Well, why not send a letter before it saying, unless you cease this use immediately, we are going to issue High Court proceedings, and do you want to nominate solicitors to act?
Again, my Lord, I can't say. I wasn't involved at that stage.
No.
I would need to take instructions. It is fair to say, my Lord, that Mr Justice Eyre was aware of this.
Yes.
He had the time.
He doesn't seem to mention it.
He deals with it briefly in his oral judgment, and he also deals with the sequence of events in his lengthy judgment.
Yes.
Well, I'm afraid I can't really assist further.
No.
A letter was not sent. That's accepted.
Yes.
And perhaps a letter should have been sent. But nonetheless, the defendant was able to respond in time, putting in evidence,
Yes.
making submissions and so on. And there was no application for an adjournment on the Friday.
No.
CTM was able to respond on the 13th with a fair amount of detailed information. And the Home Office didn't lack time to respond. It chose not to respond until the 15th.
Yes.
Mr. Green, a small point, but you asserted with confidence that there'd been no breach of the rules in the way in which you conducted yourself, or Epping had conducted itself. But I think you would agree, would you not, but tell me if not, that the practice direction which deals with pre-action conduct and protocols have not been observed.
Well, that's correct.
And one of the objectives of that pre-action protocol would be to make decisions about how to proceed. And one of the things that Somani had made clear to you, or to your authority in the past, was that it had received advice from the Home Office about the use of the hotel. And that might it not have alerted you all to the need to perhaps consider the joinder of the Home Office at that stage?
Well, the Home Office wasn't joined, and the judge below considered it was perfectly proper for the Home Office not to be joined, because the Home Office was not the controller of the hotel.
No.
Planning enforcement action, generally speaking, is directed at the persons with an interest in the land,
Yes.
or persons occupying the
All right.
land.
So CTM as the service provider.
CTM wouldn't have had an interest in the land or been an occupier either, but could have been joined. My lord, I accept, of course, the claimant could have chosen to join them, but as the judge indicated, it's a matter for the claimant.
Thank you.
My lord, in the circumstances that presented themselves to the judge when the application was made, he considered the matter properly, in my respectful submission. He looked at the gateways, and he took a rational decision in relation to those. So far as discretion is concerned, he felt, no, it was too late. The hearing having occurred, judgment about to be handed down, it was too late for the Home Secretary to become involved.
Then on that point, we looked this morning at the Better Oceanway case,
yes,
and particularly paragraph 41.
Yes.
And in that case, we have Lord Justice Mayles at 41 saying it's hard to envisage circumstances in which the court would conclude that it was desirable to add a new party in order to resolve all matters, but nonetheless declined to do so. Do you say that that delay in concluding the case would be one of those circumstances, hard though it was for Lord Justice Mayles to envisage,
yes,
that would justify that different exercise?
Yes, that's precisely.
Thank you.
But of course, this has to be understood as a finding that follows only if the judge was wrong on gateway.
Yes, yes.
And in
yes.
my respectful submission, he was entirely right on that. But if he was wrong, nonetheless, his
Well,
decision...
that's why he articulated himself in paragraph 17 as he did.
And the circumstances are certainly unusual, to say the least. Returning to my skeleton argument, page 7, paragraphs 21 and 22, the final criticism is that the judge didn't consider whether the Secretary of State should be joined in order to take part at the substantive stage. The reason, as I understand it, I wasn't present at the hearing, but the reason, as I understand it, is that the focus of Miller and Friends' submission was on joinder at that point in time to effectively fend off an injunction, an interim injunction. Given the judge's finding that the Secretary of State didn't satisfy either gateway, there was no question of joinder at the substantive stage. That simply didn't arise. But if this court disagrees, then in my submission the appropriate course is to send it back to Mr Justice Eyre, and he can consider that at that stage.
What are the terms of his order refusing joinder?
Forgive me, my lord, I didn't catch that.
I said, what are the terms of his order refusing joinder?
Is it page 32
Yes.
of the Core Bundle 1 simply dismisses?
Yes, and that would reflect the judge's finding on gateway.
Or it might be said that's for good and all. So it's too late for the Secretary of State to say, I'd like to take part in the trial. Too bad.
Yes, and that, my lord, reflects the judge's finding that the Secretary of State had not satisfied the gateway that would have justified joinder.
Yeah. Well, perhaps this point is rather important, because if we refuse permission to appeal against the refusal of joinder,
yeah,
that means the Secretary of State will have no right to take any part in the trial.
entirely true, my lord, yes.
Yes.
The Secretary can, of course, put in evidence, as has been done on 4 previous occasions.
Yes. Right. Is that it on joinder?
My lord, yes.
Yes. Right.
So we come to the substance of essentially the balance of convenience. And on that, it's helpful to, I think, bear in mind that it's at the end of the judgment that you have the balancing exercise. I don't know which version of the judgment the court is working to, but it's at paragraphs 104 onwards, where the judge sets out the factors for and against, and then reaches his overall conclusion. And that's a very helpful and clear way where the judge has indicated why and how he arrives at the balance he strikes. But as he says in paragraph 105, the factors operating in favour as follows: it will be seen that the reasoning underlying a number of these factors is more fully set out above. In relation to those factors, again using this as the summary, paragraph 106, the public interest in the enforcement of planning control is a factor of particular importance. I don't understand that to be challenged as being a relevant consideration, and the weight the judge attached to it was a matter for him. I understand my learned friend indicates that in this case the harm did not justify the injunction. But I don't understand there to be any challenge to the decision of the judge to take that factor into account as weighing in favour of the grant of an injunction.
As a general proposition, of course it's a relevant factor. To say it's a factor of particular importance seems a very sweeping statement.
Can I take your lordship then to South Bucks and Portsmouth?
Yes.
Tab 5. At paragraph 10, and I appreciate the court was taking this paragraph earlier by my own friend, Lord Bingham observed that the process of planning control is a very important process, since control appropriately and firmly exercised inures to the benefit of the whole community. And then, as a bookend, one goes to the end of the report, page 91, and one has the opinion of Lord Scott, paragraph 102, last sentence: there's a strong general public interest that planning controls should be observed and, if not observed, enforced. The judge went beyond that, of course. In his judgment, he explained why, in this case, he attaches particular significance to the public interest. Can I invite your lordship and my lady to look at paragraph 54 of the judgment?
Yes.
As I understand, there is no criticism of or challenge to what is said in this paragraph by the judge. So planning control performs a number of important functions, one of which is to allow for the issues of concern and so on, occasioned by a planning application or development, to be considered in an open public way.
Yes.
As a preamble, would the court please turn to section 187B itself? It's in tab 1 or behind tab 1 of the authorities one. Provides page 11, tab 1, where a local planning authority consider it necessary or expedient for any act or apprehended breach of planning control to be restrained by injunction, apply to the court, whether or not they've exercised or proposed to exercise any of their other powers under this part. And that section, that provision was considered at length in South Bucks and Porter. Important points to note, of course. The decision whether or not to seek an injunction is that of the local planning authority, which is the body responsible for enforcing planning control in its area. And it can seek an injunction when it's necessary or expedient. There is no obligation to seek an injunction, of course, and all enforcement action is discretionary. In addition to seeking an injunction, a local authority has power to serve an enforcement notice. If it considers it expedient, it has power to serve a stop notice or temporary stop notice if it considers it expedient. All these enforcement powers turn on the discretion of the authority based on its assessment of the circumstances at the time. A local authority presented with a breach of planning control can choose to take no action, it can negotiate, it can invite a planning application, or it can take formal enforcement action. And it's in that context that it's quite wrong, in my respectful submission, to suggest that there is delay on the part of an authority simply because it doesn't, at the first opportunity, take enforcement action. It's said against the local authority.
Where is the authority to support that proposition?
My Lord, that's, with respect, plain from section 187B itself, and indeed plain from all the enforcement provisions. There's no obligation to act. A local authority can choose to act if it considers that the breach of planning control is unacceptable. And that's a public law decision for it, and it alone. It's said against the local authority in this case that it didn't act either on or after the 15th of May when it became clear that the defendant was not going to seek planning permission for the use of the hotel. At that stage, the protests, the disorder, the criminal activity had not reached the pitch which it did later. And there was nothing remotely wrong or blameworthy in the authority not seeking an injunction or other enforcement action at that stage. The defendant is not prejudiced by the authority choosing not to take enforcement action then. And if circumstances change, there's nothing wrong with the authority taking a different view. And that's what happened in this case.
Sorry, could you just repeat that? Just that last sentence.
My lady, there is nothing wrong with the authority choosing not to take enforcement action at one point in time, and when circumstances change, taking a different decision later. So although it's said that there has been delay on the part of the local authority, with respect, that simply reflects the local authority's changing view as circumstances on the ground have changed. What was tolerable, perhaps, in May, was intolerable by July.
We are not at the moment deciding an appeal from a decision at trial. South Bucks and Porter says a great deal about the availability of injunctions under Section 187B of the Town and Country Planning Act. It says nothing about American cyanamide and the balance of convenience. American cyanamide wasn't even cited, let alone referred to in the judgments. At the trial of this claim, it may be that any argument by the defendant based on delay will not carry much weight. But the main burden of the submissions on the other side from you is that it carries a great deal of weight on an application for an interim injunction pending the trial.
Well, I understand that is the argument.
Yes.
But to talk of delay
Yes.
in these circumstances is just wrong. This is not akin to a private individual sleeping on their rights, sitting on their hands while their rights are being infringed, which may well have a bearing on the court's willingness to grant an injunction to uphold those rights later. Delay, late fees and so on, well-established principles when a court is granting an injunction in favour of a private individual. This is a completely different jurisdiction. And the local planning authority could and should change its mind when circumstances change. A decision not to take enforcement action at one point in time doesn't mean it cannot take a different decision at a later point in time if circumstances have changed. And on the evidence, circumstances had undoubtedly changed. It said rightly that the use of the hotel to house asylum seekers from 2020 onwards was unproblematic. And that's right. And in those circumstances, it's not entirely surprising that the local authority took no enforcement action. There was a time when a planning application was put in and it wasn't determined. And whatever one may say about that, in the absence of planning permission, breach of planning control, but the authority didn't take enforcement action.
It would have been surprising if it had, bearing in mind that an application had been made
yes.
and it had sat on it for 13 months.
Well, a point that Mr Justice Eyre makes as well, I think, in his judgment. Plainly, that's right. But in theory, until planning permission is granted, if the authority is right that there's a breach of planning control, until planning permission is granted, it can take enforcement But it didn't, because the use of the hotel at that point in time was tolerable. In my submission, the arguments about delay in this case simply misunderstand what the local authority is doing when it's deciding whether or not to take enforcement action under section 187B, indeed under the Town and Country Planning Act. It's deciding whether at that point in time it's necessary or expedient to seek an injunction, and that will change if circumstances change. Otherwise, local authorities would have to rush off to court at the moment a breach of planning control occurred. If it were going to be said against them, you have delayed in seeking an injunction. Well, that's not how it operates. It's not how it should operate. Local authorities should exercise a discretion when considering whether or not to enforce. While section 187B is open, I just want to make one other submission relating to its terminology. It does not specify matters that must be taken into account or must not be taken into account. Obviously, the purpose of an injunction is to restrain a breach of planning control. So, has there been a breach of planning control must be a primary consideration. Is it necessary or expedient to seek an injunction? That's going to be a consideration. But the factors, is this the right case for an injunction or not, that's left entirely to the local authority to decide. There are no factors that are mandated to be taken into account or to be excluded. So we are in the realms of a broad discretionary judgment when a local authority comes to decide should it seek an injunction or not.
There's a good deal said about this in South Bucks and Porter, isn't it? Some of it quoted by the judge. It's not simply a broad and unfettered discretion to do whatever it likes.
No. It's got to be relevant to the power. I accept that, and I don't criticise for one moment the way it was put below. In my respectful submission, the judge got it entirely right. There have got to be factors relevant to the breach of planning control, relevant to the injunction, that sort of thing. So I'm not suggesting the judge got it wrong in any way, but it's alleged that the local authority left various things out of account. Well, my lord, that's relevant as a criticism of the authority only if it was required to take them into account, either because statute required it or because they were so obviously material to the discretion being exercised. But even if there is criticism to be made of the council, the role of the court is not to review the council's decision, it's to come to its own view on the facts. And that is very much the heart of the decision in South Bucks and Porter. The court is exercising its own original jurisdiction. Well, there's been some reference to the sequence of events, and simply for the court's note, in the skeleton argument before Mr Justice Eyre put in by the local authority, the council, which is in the bundle prepared by Somani Hotels. It begins at CB 56.
Yes.
And there is in it, paragraphs 13 to 35, a very detailed chronology of events. Because there have been questions as to what communications there were between the council and other bodies. The court may find that a helpful account of events. Well, I was going to refer very briefly to the Ippswich case and then go through my submissions on the challenge made by Somani.
Yes.
Ippswich is at tab 15. As the court knows, this was a case in which two applications were heard together, one by Ippswich, one by East Riding of Yorkshire. The Ippswich application was made when the use of the hotel in question had begun. The East Riding of Yorkshire application was made before the use had begun. And Your Lordship and my lady will have seen that an application can be made under section 187B where there has been a breach of planning control, where there is an apprehended breach of planning control. The court was taken to paragraph 2 at 223 of the bundle, and that is in substance almost word for word the same as paragraph 11 of Malone and Friends' skeleton argument, Mr Brown's skeleton argument, which sets out the legal framework. There was reference at paragraphs 21 to 26 of the system for asylum support in this country, and as Mr Brown confirmed in his submissions earlier today, that hasn't changed, not significantly. Finally, at this stage, page 242, paragraphs 119 to 124, there is an analysis by Mr Justice Holgate, as he then was, of the harm that will be said to arise in the event an injunction is granted. I suppose it's really paragraphs 123 and 124 when the effect on the Home Office is considered in particular. The judgment in Ippswich was, of course, before and referred to by Mr Justice Eyre below. So he had the benefit of all of this learning. The witness statement put in, the witness statement that the Secretary of State would like to put in, adds, in my respectful submission, nothing of substance to what is in the judgment in the Ippswich case. If I can return now to the judgment.
Yes.
Paragraphs 104 onwards, CV 135,
Yes.
in the bundle I'm looking at. That sets out the factors for and against the grant of injunction. I've referred to the first factor, the public interest. The second factor was deliberateness. And it's said by both appellants that the judge got that wrong. In my skeleton argument at pages 3 and 4, I set out the passages, the main passages, where the judge deals with deliberateness as an issue. Paragraph 60, 65 and 107 from the judgment itself. And in my respectful submission, there is nothing wrong in logic or reason with what the judge says there. The defendant knew that the local planning authority considered the use of the hotel for asylum seekers to be a breach of planning control. It knew that. It knew that the local authority was expecting a planning application and said that it would make a planning application.
Well, it had been expecting one until the 15th of May.
Yes, well, the authority had been told an application would be made.
Yes. And then it was told that
Then it was told it wouldn't.
Yes.
But it knew, the authority considered the use unlawful and could therefore be enforced against. The hotel operator could have avoided enforcement action by seeking planning permission, and it's not entirely clear why it hasn't sought planning permission. Or if it was really satisfied that what was proposed was lawful, it could have applied for a lawful development certificate.
Well, perhaps, who knows, it took account of the way in which it had been treated in those 13 months in its prior application between, what was it, February 23 and April 24. It puts in an application for change of use and Epping does nothing.
But of course, the fact is there was an application then before the council. It's difficult to see how it could have been expedient to enforce in those circumstances. That possibility was removed. The defendant chose, having said it would apply for planning permission, chose not to. Now in 2024 or 2023, the use was not controversial in the sense that there were not public protests.
So what are you saying? In 23, it was on your account in breach of planning controls, but bluntly, it wasn't causing a problem, so there was no need to do anything. That's a very simplistic way of me to put it, but is that it?
Fair enough, my lady, yes.
So the only real difference is the public protests.
That's the trigger. Well, yes.
The public protest started in July. Why does it take until August to do anything?
Well, the council has its own administrative processes. There was a council meeting on the 24th of July. and both before and after that meeting, the council had written to the Home Secretary asking her for this hotel to be closed. And those pleas fell on deaf ears.
Then you say that the Home Office was not necessary or even desirable party to the claim and should be allowed to take no part in it. Instead, train your fire on Somani Hotels.
Well, Somani Hotels operates the hotel.
Yeah, I understand.
And any injunction would have to be against Somani
Yes, it
Hotels.
would. So supposing that your case is that the hotel owner should have applied for planning permission and what? Cleared out the hotel until that had been determined.
Not at the beginning.
No, 2025.
At the beginning, I mean April, when an application was promised.
Yeah.
At that point, the use was not problematic.
Yes.
So at that point, I don't imagine for one moment the local authority would have said, stop the use until we determine your application.
Yes. The judge says that Somani made a deliberate decision not to apply again for planning permission. Well, suppose instead of writing on 15th May to say, take advice from the Home Office, we're not going to. We're told we don't have to apply, there's no material change of use, so we're not applying. Suppose instead they said, we've taken advice from the Home Office and they take the view that there's no material change of use, so we don't have to do anything, but just to be on the safe side, we'll apply for a certificate of lawful development. I don't know how long that takes. And at that stage, no great controversy, and then the protests begin in July. So, would the case be any different?
Depending on the steps taken by the hotel to regularise the matter.
Yes.
Why would I suspect not?
Yeah.
Everyone's now speculating about an alternative reality.
Well, of course, but it doesn't look to me as though, even if they had, the council would have passed the same motion and written the same letter to the Secretary of State. At least that seems a reasonable inference. And yet the judge 6 or 7 times mentions the behaviour of the hotel company in not applying for planning permission or certificate of lawful development as deliberate.
Entirely appropriate, because of course the hotel did not seek either planning or lawful development.
I understand that.
And either of those processes.
Most decisions by landowners, occupiers, not to seek planning permission, deliberate, aren't they?
If they are told by the local planning authority, the enforcing authority, you are in breach of planning control, they have, in this sort of situation, 3 choices. Do nothing and see what enforcement action the local authority takes, seek planning permission or seek a lawful development certificate if you don't think you need planning permission. And in this case, the hotel chose to risk it.
And help me with this, it's not an area which I have any expertise. If they had applied for a certificate of lawful development, that's a question of law. That's not a question of do we think it's a good idea to grant planning permission. It's a certificate that no planning permission is required because there has been no material change of use.
Well, absolutely. Yes. Sections 191 and 192 of the 1990 Act, and they're in the authorities bundle. Well, I should add this. Anyone can apply for planning permission. Anyone can apply for a lawful development certificate in relation to land. The Home Office could. CTM could. I could. You don't have to have an interest in land to make an application for planning permission to develop it or to obtain a lawful development certificate. Anyone can.
You're saying that the Home Office or CTM,
The Home Secretary,
anybody else,
yeah,
could apply to a local authority for a certificate of lawful development. Yeah. That is a certificate that no planning permission is required.
Sections 191 and 192, I think, begin with, broadly the words, any person may apply. There is no requirement that a person has an interest in land in order to apply for lawful development.
Well, there we are. Anyway, now I'm better informed. Maybe it's not relevant, but there we are.
Well, if I can go through as briefly as I can, my skeleton argument, and the grounds raised by the hotel. First ground is the deliberately ground, and I think I've dealt with that as best I can.
Yes.
Ground 2, the issue of hardship. And it said that the judge didn't properly grapple with the limitations of the evidence before him. I deal with that at paragraphs 17 to 21 of the skeleton argument. But I would just say this, in relation to the suggestion that the judge was unaware of the limitations of the evidence, he refers to it at paragraphs 4, 67 to 69, 77 to 79, and 103. My Lord, the judge was well aware that he was dealing with an interim application where the evidence was going to be less full than it would be in other circumstances.
The complaint is really that there was little or no evidence before him as to what the practical consequences would be of the 138 people having to leave the valley. Of course, it was not physically impossible for them to leave, but Mr. Brown's case on this, in effect, is not really any of Somani's business, but Mr. Brown's case is you have to take into account what is to happen to them, not only how far will they have to move, what onward pressures that will place on the system and so on. And that's highly relevant to the balance of convenience. And the judge didn't know anything about that.
Well, my lord, he'd be none the wiser having looked at the witness statement from the Home Office, which deals with none of that. It just said that it would be difficult. So if the court is looking for illumination on the difficulties, I'm afraid it's not going to find them in the evidence presented by the Secretary of State. What the judge did have the benefit of, however, is the analysis in Ippswich by Mr Justice Eyre. I've taken the court to those passages already. He sets some of them out. So he was well aware of the issue and he attaches considerable weight to it.
Yes.
Had the Secretary of State actually been joined and been permitted to rely on the witness statement put in, it would have made no difference because it frankly added nothing. But given the material that was before the judge, which he recognised was limited, he was entitled to reach the conclusion that he did, well within the bounds of his discretion. Well, I was going to move on from hardship. The other point I make is that a criticism is levelled at the council. It didn't look at hardship, either for individual asylum seekers or for the Home Office. It's curious, therefore, that the evidence put in by the Home Office doesn't deal with the impact on the asylum seekers at all. And says nothing of substance about the impact on the Home Office itself. But perhaps the more important point is that in deciding whether or not to grant an injunction, the court is not judicially reviewing the exercise of the local authority's enforcement power. It's deciding for itself, on the evidence before it, is this a case where an injunction is appropriate? The fact that the local authority got it right or wrong, in someone else's view, is neither here nor there. And that's made perfectly clear in South Bucks, unfortunately. The decision of the local authority can be a material consideration, as the guidance from Lord Justice Simon Brown, as he then was, indicates. The decision of the local authority, the democratically elected body, can be an important consideration. But if one looks at the exercise carried out by Mr Justice Eyre below, paragraphs 104 to 119, he doesn't refer to that at all. I'm going to move on, my lord, if I may,
Yes.
to the stop notice point, which I think your lordship has very neatly dealt with. The judge was entitled to put on the basis
We need not trouble you on
I'm
Mr
grateful.
Riley Smith's ground 3.
Ground 4 is the delay. And again, my lord, I believe I've dealt with that. There is one final ground of challenge. It's a new one raised by Mr Brown. It said that the judge should not have expressed a view on the strength of the council's case. If one goes to the judgment at paragraphs 93 onwards, Your Lordship, and my Lady will see that it was recognised that ordinarily, at the interim stage, one doesn't look at the strength of the party's case, but in this case, exceptionally, each side was saying, my case is so strong, you really should take account of it. And the judge...
But isn't that what Lord Diplock warned against in Cyanide? Parties very often say that. A claimant says, my case is so strong that there's no serious question to be tried, but that I'm in effect entitled to summary judgment. Defendant conversely says, nonsense, you've got no case at all.
Well, my difficulty is, this point was not raised in either skeleton argument. It was raised for the first time today.
No. I thought it was at the heart of the applications for permission to appeal.
No, the issue of the relevance of the strength of a party's case was not raised in Mr Brown's skeleton argument, not raised in Mr Riley Smith's skeleton argument, and I'm simply not able now to provide authority for the proposition that it's appropriate at the interim application stage, on occasions, to consider the strength of a party's case. I just don't have that case law to hand. So, if the court would like submissions on whether that was a course open to the judge,
Yes.
I would like an opportunity to put in written submissions on that.
Yes, I think you're right. Looking at Mr. Riley Smith's skeleton argument, what is said is that the judge's assessment of the strength of the planning case was wrong, not that he was not entitled to embark on such an exercise. I think that's right, and I think that's true of insofar as Mr. Brown ventured on that territory. That's true as well. Yes.
Okay.
So we don't need further submissions on that.
Great. May I just take a minute?
Yes.
Well, unless there's anything else.
Thank you very much, Mr. Green. Very helpful.
My Lord, I'll make reply submissions essentially in the order which Epping took the points. The first point made in respect of the intervention application was to note that there was no application by the Secretary of State to intervene in Ipswich or the other cases determined in 2022. That is factually correct. I cannot speak for decisions made in respect of other cases 3 years ago, but that tells you very little about the desirability question when the application was in fact made in this case. It is right, as the court noted, that the service providers were present in those cases and were therefore in a position to provide evidence in relation to the discharge of the statutory duty. But beyond that, the presence or otherwise of the Secretary of State in those authorities sheds very little on the application of the legal principles when the application was in fact made here. The authority then made submissions about the events of the 12th to the 15th of August, i.e. what occurred. I made my submissions this morning. I indicated that it was unsatisfactory, and as we noted in our skeleton argument, we did offer an apology to the judge. But the practical question is where one goes from there, not so much how one got there. We say that when the application was made, and the right course was to consider the application of those principles at that time. And true it is, it would have been relevant to consider the events of the previous week. The evidence indicates what the Secretary of State's decision-making process was. The court has explored the point we would adopt or make the submission rather that the absence of any compliance with practice, direction, pre-action conduct is of significance. This injunction was not brought on in a structured way which would have properly enabled the necessary evidence to be obtained. In addition to the references which were before the court in relation to what happened prior to the application, the court has identified the correspondence from the council leader in July 2025, that's supplementary bundle page 199, which effectively foreshadowed this injunction. And the court will therefore have seen that certainly as a political...
Well, it foreshadowed something. I thought you were going to say it didn't foreshadow this injunction.
No, my lord's absolutely right. That's a more accurate way of putting it. It foreshadowed concern. So the fact of the issues arising from the bell had been identified at a political level. It was absolutely right. It did not in fact state that any court proceedings were going to be issued. So to that extent, there was, it is right to state that there was nothing from the authority and the proceedings were therefore issued out of the blue. just been indicated alternative approaches that could have been taken, and of course on the part of the Secretary of State some thought was given to alternative approaches. It is right that we could have waited for the reserved judgment. We didn't in fact know it was going to be handed down in the way that it was, i.e. a detailed written judgment. We could have then applied to be joined and sought to discharge. An alternative course would have been to have applied under CPR Rule 40.9, which allows for a party affected by judgment to make an application. So there are alternative routes, and we were aware of that. But in substance, they're all driving at the same outcome, which is allowing the Secretary of State to make representations and ask the court not to make the injunction or discharge it. And therefore, it's improbable that anything would have been obtained by a different procedural route. That's what I propose to say on the intervention application. Turning to the substantive submissions. The authority started with paragraph 106 of the judge's judgment, which noted the public interest. I simply invite the court to contrast the judge's sweeping analysis at 106 of this judgment with paragraph 114 of Ippswich, where Mr Justice Holgate correctly identifies that the real question is the nature and extent of the harm, not the mere fact of public interest. On the question of delay, Epping states correctly it can choose not to act, but it then faces the consequence of that choice when asking the court to exercise an equitable discretion. And as to that issue, delay is always likely to be relevant. And in these circumstances, on an application for interim relief, the fact of very clear and substantial delay over many, many years is significant. Because one goes...
Mr Green says in answer to that, nobody minded very much in 2022, 3, 4. Even in May 25, there was nothing much going on, but then things change in July when there's an explosion of protest leading to the Council's resolution and so forth.
Yes, well, one goes back then to the claim form, which pleads the planning harm, which is said to justify the injunction. And where we appear to have ended up is that the first two of the three factors are not now said to be factors which justify urgent injunctive relief. So impact on GP surgeries and the alleged propensity to crime. Those were factors which were present from day one, insofar as there was any substance in them. And the court has my submissions on that. Epping has effectively conceded before this court that this was in truth only ever about protest. So the third of the three factors identified in the claim form. So the question then is the Section 187B instrument the right course to manage the consequences of protest? Entirely unprecedented course. None of the authorities address the planning injunction in those terms, because in truth that is not a substantial planning harm, and indeed this judge did not consider it to be. He attached limited weight to it. So what is relevant then, in terms of the question of expediency on the part of the authority, or this court exercising its own original jurisdiction, is whether that is commensurate to the harm. So is the injunction sought commensurate to that specific harm? And that requires consideration then of the nature of that harm. And importantly, there are of course non-legal routes available to local political leaders. The court has the witness statement in the bundle of Councillor Whitbread, which is supplemental bundle 1629. We just very briefly ask the court to consider that, because the councillor does express her views in relation to that. And what Councillor Whitbread says at paragraph 9 on page 3 of her witness statement is that the situation has significantly deteriorated in recent weeks. Large-scale protests are now taking place regularly outside the Bell Hotel, which spill out onto the High Street. While many local residents strongly oppose its continued use as accommodation for single adult male asylum seekers, they do not support disruption or disorder. Some of the protests have attracted individuals and groups from outside the area, including extremists who seek only to provoke and divide. So what the local councillor is telling us on behalf of those for whom she speaks in Epping is that they do not support protest. Protest does appear to, at least in part, be driven by what the council is describing as individuals and groups from outside the area, including extremists who seek only to provoke and divide. And the issue then is the extent to which those local political leaders can communicate and explain their view as set out in the evidence, namely that the local residents of Epping do not wish for these protests to take place at this site. That is because the site, as the evidence explains, is near to local schools, it is near to a high street, and the protests substantially interfere with the life of local residents of Epping. That concern then, as is indicated, we say, by the evidence, certainly as a starting point, is fundamentally a matter for local dialogue by those responsible. Now, it's a matter for all those local political leaders as how they go about engaging and managing that disturbance. But it is certainly right to acknowledge that this application has not so far proven to have achieved the objective of ending those protests, because it is simply the wrong tool for doing so. The planning injunction process is not designed to be an anti-protest injunction. If the protests are unlawful, there are different, more proportionate and targeted measures that are available. If they are lawful, as this judge found, then that is a consequence of living in a free society. And the best that one can hope for in those circumstances is the process of engagement, which explains the legitimate concerns of local residents. So we say that does reveal in very stark terms the inappropriate nature of this specific relief sought, and why matters that are truly proper to planning concerns should fundamentally be addressed through the planning regime, not through an interim injunction of this nature. I can turn my back for a moment. Unless I can assist for those who are reply submissions.
Thank you, Mr. Brown. Mr. Riley-Smith.
My lords, my lady, good afternoon. Just two very brief points in response, if I may. The first is to respond to my learned friend's submission as to one of the justifications for not engaging in pre-action correspondence was because they say there's no evidence that the defendant would have complied with the request. The issue with that stance, as your lordship noted, it partly robbed the appellant of the time for preparation, but it also robbed the appellant the ability for dialogue. That dialogue may not have been, well, we'll stop the use straight away, but I can't speak for that. I don't have instructions, there's no evidence either way. But theoretically, it could have allowed for, well, here's more detail of our position, why we think we don't need planning permission. Here's a disclosable barrister's opinion as to this effect. Or perhaps, well, your ladyship noted the lack of effectiveness when the approach was taken previously of putting in an application, it would have allowed for dialogue of, well, if we put an application in this time, will it be determined? All of that was robbed by the lack of any pre-action correspondence, and we would submit it would entirely undermine the purpose of the pre-action regime if it can be avoided by simply assuming the outcome wouldn't be what the claimant wanted, which is the defendant to simply accept their position. So we say that isn't an adequate explanation as to why pre-action, no notice was given at all as to this. The second point, and my learned friend for the Secretary of State has mostly stolen my thunder in relation to this, but I'll just briefly highlight one or 2 points. It relates to what the appellant would also say is really the confirmation rather than the revelation from my learned friend's submission that this was an injunction about protests. That was the change in circumstance. In the context of delays, your ladyship has noted they started in July. It doesn't provide a solution. But just 2 brief points on why a planning injunction is not appropriate to deal with protests. The first is, and I don't think my learned friend addressed this in these terms. My apologies if he did. Firstly, there are other controls, such as had already been done in this case, the Section 14 public order. What hadn't been done, or a question asked, is whether an injunction could be sought against the protesters. And the reason I raised that point, just to give the court a reference to my High Court skeleton at paragraph 32, at core bundle page 84, it was an unreported case.
Just a moment.
My apologies. Paragraph 32 at the bottom of page 84.
Sorry. Page 84.
This is of Somani's call bundle.
Yes.
Just an extract from my skeleton where the point was raised, I accept it was an unreported case, but it's the only one the appellant's aware of, in Carmarthenshire County Council, where they sought a planning injunction which was involved a hotel where protests were occurring. That was unsuccessful, but it was followed by a successful injunction against the protesters by the hotel. And that's simply to illustrate, I think this isn't necessarily unprecedented. There seems to be, albeit unreported, a case which involved protests. And the outcome in that was eventually an injunction against the protesters, just illustrating there are other, and the appellant would say more appropriate, remedies to where protests are causing such a concern as to warrant action such as this. And the second point, it is just to raise the tension or the concern of reliance on protests in a planning injunction at interim stage. Because it is the case, of course, that it may be at the final hearing an injunction, if it's granted, is lifted. What we would say is unclear, and it questions a justification, using protests as a justification, is if following that final trial, if the planning use is found to be lawful, whether that would address the protesters' concern. We would say it's a fair assumption that the protesters were not protesting against the planning status of the hotel, rather the use itself. And so using protests as a justification for an interim injunction, to, as it were, hold the line, or not hold the line, to change the circumstances until a final trial, we just question whether that's inappropriate, or it brings into question the use of planning injunctions against protests. The second point is also, while it may, I do accept, although it hasn't actually occurred in this case yet, that the removal on an interim basis of asylum seekers from a hotel may negate protests occurring for that period of time. That is not to say that it doesn't lead to protests at other locations against other hotels housing asylum seekers who have seen that protests can be a justification. That would be an unintended consequence, and it was a point I made clear when I made my submissions to seek permission to appeal for Mr Justice Eyre. I wasn't suggesting that was in any way his intention, but it raises just a concern or a warning about the use of protests to justify planning injunctions. I appreciate they are contextual points, perhaps more than strict legal points, but it plays into that context. Unless I can, well, first, if I may just turn my back. Unless I can assist any further, those would be the appellant's submissions and responses.
Thank you very much. We're just going to rise for a few minutes. I don't mean that we're going to give you a judgment or even a decision in a few minutes, but what we need to discuss is when we'll be in a position to give a judgment.
All right.
Questions where?
Yes.
We'll find out. We've got that decision. If there's things involved, that's going to affect
We can hope maybe write on.
Yes, just send it an email to Mr Justice Eyre. Okay. Good point.
Hello. Yeah, is everyone ready to continue? How's it going, Davies? Got the skeletons, right?
Yes, very good.
All rise.
Because of the great urgency of this matter, we will aim to give judgment at 2 o'clock tomorrow. We will probably use the same technique as the Supreme Court, that is to say, to have a reasoned judgment of some length, but also a summary, to read out and immediately publish the summary, to transmit the full judgment to counsel with the usual request for typos and so forth to be noted, and publish that judgment either later tomorrow or Monday. If it proves impracticable for us to meet the deadline, we will let people know in advance, but we will have the case listed for judgment. Technically not before 2 o'clock, but aim to do it at 2 o'clock. In the usual way, if leading counsel in particular are unable to be present tomorrow, it will be sufficient for one counsel for each party to be there. Whatever the decision, we will give some time for written submissions on costs and so forth. That's all we can say at this stage, so we will see you, or most of you, tomorrow.
Thank you, my lord.
Thank you all very much for your assistance.
All rise.